How do you prove a cancer case in Maryland? This is going to be a longer form video because I get lots of calls about this, and it can be very complicated in Maryland to bring a cancer case. Here's why. Let's get started. So the ingredients of a cancer case include, number one, proving that there's been some kind of medical mistake, usually a misdiagnosis. Either something was seen and you were told that it was nothing, or it was totally missed. Either way, that's medical negligence, but that's only part of the story. And most people who call me, there is some medical mistake, there is some misdiagnosis. Either it was missed or they saw something and they said it was nothing. But here's where it gets more complicated. You have to prove two other things. First, you have to prove that an earlier diagnosis would have made a difference. What do I mean by that? Let me give you an example. Suppose there is a 2-month delay and you have cancer and it was a stage 1 had they diagnosed it early, and it's still a stage 1. Unfortunately, that wouldn't be a case under Maryland law because the outcome wouldn't have been different. Only if there's a later stage cancer. My example, a stage 1, it would have to be months and probably close to a year of a delay in diagnosis where that cancer went from a stage 1 to maybe a stage 3 or stage 4. That's the first complicating factor. The second complicating factor is that under Maryland law, you have to prove that if the cancer was diagnosed earlier, you would have had a greater than 50% chance of 5-year survival. But with the medical negligence, you now have less than a 50% chance of long-term survival. How do you prove that? Well, there are lots of statistics. They're called life expectancy statistics for every cancer. And that literature will tell you what the 5-year survival rates are. Now, in some states, you have something called loss of chance. Loss of chance means that even if an earlier diagnosis wouldn't have put you over 50%, let's say you had a 40% chance of diagnosis had the doctors gotten it right, but now you only have a 10% chance. Some states allow you to bring a lawsuit for that loss of chance. Of course, if it was me, God forbid, I would like to have a 40% chance of living versus a 10% chance of living or 20% chance of living. But Maryland does not recognize that type of case. So again, you have to be over 50% 5-year survival if the cancer was diagnosed earlier, and because of the medical negligence, you're now less than 50%. So there's a lot that goes into a cancer case, and when I tell this information to clients, they're very disappointed, and I can understand why, because it's very complicated. What happened was the legal world and the medical world kind of conflicted on this. So in the medical world, a doctor will tell you that treatment would offer you all these different possibilities, and in the medical world, the term possibility is totally fine. We all want to have the possibility of getting better. However, in the legal world, we deal with something called probabilities. The term is more likely than not, and that's a higher standard than possibility. So when the medical world and the legal world come together in a cancer case, it can make a cancer case in Maryland very difficult. I hope you found this video informative. If you did, please leave some comments below. And if you have a question about a cancer misdiagnosis case, please leave your information below and I'll get right back to you.